calling on case number 1212/18 of the SABWiL Human Rights Court. The parties are Providence Hope High versus MEC for Education, Northwest and another. May the parties begin.
For the applicant.
Okay.
Yeah.
Apologies, Your Worship.
No, don't.
Worship, if it, Your Worship, so the pieces of court, I may stand as I address you
Yes.
in our openings. Worships, we've been formally introduced or informally introduced prior to this, but just to introduce myself and my counsel, if I may. My name is Thabang Mokhatle, and I'm senior counsel for the applicants in this matter. And I'll let my fellow colleagues introduce themselves.
If it pleases the court, my justices, my name is SABWiL. I'm second counsel for the applicant to this matter.
It pleases the court. My name is Talent Maluka, and I'm the third applicant.
Your Worships, if we may, we'll just sort of go straight into our arguments and introduce the matter. As the court, as it pleases the court, obviously the facts around the case have already been presented, so we won't waste time into going into those details, but proceed on the applicant's submissions on these. The background to the arguments and submissions which will be made by the applicants this morning are captured quite effectively in the preamble of the Constitution, which will be the basis on which we will justify the submissions made by the applicants. In particular, I'd like to point the court to the preamble, and in particular the last sentence thereof, which basically says that the Constitution
What
seeks...
is the page number? Page?
In our heads of argument, Your Worship, it's page number 1.
Page number.
Paragraph 1, in which particular the Constitution of the Republic states that it seeks to ultimately improve the quality of life of all citizens, being included into the subsidy allocation policy and for an educational purpose, and therefore falling within the right to a basic education as encompassed in section 29 of the Constitution. So does the sanitary pad initiative fall under the right to education? Your Worships, I point to section 1A of the Constitution, which emphasizes that based on the values of human dignity and equality, apologies, Your Worship, the Constitution, section 1, emphasizes that its provisions are based on the values of human dignity, equality, and basic human rights and freedoms. In particular, the right to dignity, section 10, and the right to equality, section 9, will be considered as we unpack the right to basic education, section 29. The right to basic education is mutually inclusive of the right to human dignity. Your Worships, this is one of the key submissions we're making this morning. And as we go, I trust that it will become clearer why. In the case of Minister of Home Affairs and others versus Swachinuka and others, 2004 judgment, the court held that the right to dignity is an inherent right to be afforded to all persons irrespective of their social standing. Dignity, like the right to equality under section 9 of the Constitution, does not discriminate based on race, gender, sexual orientation, or religious beliefs, amongst others. The court in Home Affairs versus Swachinuka did expand on the connection between the right to education and human dignity in particular, in stating, and I quote, "Freedom to study is also inherent in human dignity, for without it, a person is deprived of the potential for human fulfillment. Furthermore, it is expressly protected by section 29(1) of the Bill of Rights, which guarantees everyone the right to basic education," close quote. Section 6(2)(b) of the Children's Act number 38 of 2005 further expands on the connection between the right to education and human dignity, as it mandates that any actions or decisions which are taken with regards to children must respect their inherent dignity. Therefore, there cannot be a determination on the right to education for child learners which does not take into consideration the dignity as well as what is in the best interest of such learners. The right to education is a key socio-economic right. A further submission for the applicants, Your Worship. The court and governing body of the Juma Masjid Primary School and others versus SA, non-official, it's a 2011 judgment of the Constitutional Court, explained that the right to basic education is a fundamental socio-economic right, which is positioned at, and I quote, promoting and developing a child's personality, talents, and mental and physical abilities to his or her fullest potential, close quote. This argument is reiterated in the preamble to the Constitution and is quoted in the introduction to our arguments, which is at paragraph 1. Our further submission is that an interpretation of Section 29(1), which excludes the sanitary pad initiative, would go against the very values of and rights of dignity and equality, and therefore be unconstitutional. It has already been established that the right to basic education cannot be interpreted or read without balancing the right to dignity with it. Education and dignity are therefore mutually inclusive. In addition, Section 9 of the Constitution indicates that all persons are to be treated and regarded equally, meaning that no person should be discriminated against on the basis of, amongst others, their gender. In this case, the girl child would be discriminated against and denied access to education on the basis of a natural biological occurrence which happens to take place for learners of the female gender. Section 36 of the Constitution only allows a limitation on a right contained in the Bill of Rights where such an interpretation is reasonable and justifiable in an open and democratic society and is based on human dignity and equality. An exclusion of the sanitary pad initiative from Section 29(1) would constitute an unreasonable and unjustifiable limitation on the right of the girl child to attain basic education, as it would go against their rights to dignity and equality as above considered or regarded.
So are you saying Section 36 is not relevant?
Your Worship, that's our
In this
submission.
case.
We're saying that it cannot apply. It cannot apply to this purpose, and it would be on the basis that, first of all, it is not justifiable. There are no submissions, and I will obviously allow our learned colleagues to touch more on that because they're of the opposite view. But our view is that there is no justifiable reason to limit the right, particularly to the girl child, to access education based on 29(1). And saying that they would not, and saying that the sanitary pad initiative should be excluded from this right, essentially is saying you're trying to limit the right of those girl child learners to access basic education, which in our submissions we're saying it cannot apply. An exclusion of the sanitary pad initiative from Section 29(1) would constitute an unreasonable and unjustifiable limitation on the right of the girl child to attain basic education. Therefore, on the question of whether the sanitary pad initiative falls within Section 29(1), counsel for the applicant puts it forward that it does in fact fall within this right, read together with Section 1A, Section 9, Section 10, and considering Section 36 of the Constitution as already explained. Your Worship, I'd like to move to the second submission to be made, and I will hand over thereafter to my colleagues to remain or to argue on the rest of the submissions. Can the sanitary pad initiative be said to fall within the subsidy allocation policy? In the MEC's explanation to Reverend Molopo on the scope of the subsidy allocation policy, or the policy referred to hereafter, it was pronounced that there are three main areas which the policy will cover and which warrants the Department of Education to allocate funding to a school, namely for the following three purposes: A, an educational purpose; B, for school administration; and C, feeding schemes. The applicant's position in this respect is that the sanitary pad initiative does fall within the scope of the policy as an educational purpose, as will be shown below. The exclusion of the sanitary pad initiative from the subsidy allocation policy contradicts the educational purpose element of the policy. Your Worships, it is our submissions and on the findings made by Reverend Molopo as well as Professor Mbokoto in relation to the absenteeism of girl learners, and which confirms, therefore, the far-reaching impacts on the right to education that failing to provide sanitary dignity to girls will mean. This cannot fulfill an educational purpose, and this cannot be the reasonable interpretation of Section 21A. Providence High has reported an average of a 15% drop in the educational performance of girl learners from boy learners in 2016 alone, due to lack of access to sanitary products.
Just to interrupt, what will you say if there's argument that a boy child also can also say if they go for circumcision, the education must also pay for that.
Yes.
What is your submission on that? Do you agree with that? That you can compare the two, the girl child having to be given sanitary pads and the boy child will say, if you're giving sanitary pads to girl child, then we as boys, we also need to be included in the act as a policy, so that when you go for circumcision, education must also pay for that.
Your Worship, respectfully, I'd like to disagree with that, and on the basis that circumcision, to my understanding, Your Worship, is a once-off event. Menstrual cycles happen every month for a woman between 4 to 7 days. This has a direct implication on their participation at school. The implications on the male learners, and I'm not in the position at this moment, Your Worship, to expand on that and what implications they may have, but again, the focus here is on the girl child learner and the actual impact, as has been indicated from the statistics. Girl child learners for at least between 4 to 7 days in a month are going to be missing school because of a natural occurrence. I don't think we can equate them to be the same thing. If I may proceed?
Yes.
Providence High reported an average of a 15% drop in the educational performance of girl learners from boy learners in 2016 alone, due to the lack of access to sanitary products, which resulted in a non-attendance at school. Without sanitary dignity, the number of girls who are recorded as absent will increase, meaning the educational success rate of many girl children in this country could be jeopardized. It is therefore submitted by the applicant that the sanitary pad initiative can be included in the subsidy allocation policy as an educational purpose, given the far-reaching consequences and limitations it would have on the access to education for many disadvantaged girl learners in South Africa. Your Worships, this is where my submissions end, and I will hand over to my learned colleague, Sivu, who will continue with the remainder of this applicant's submissions.
Thank you. Just maybe to add something, because this is a learning process. In court, usually you will say after you finish, you will say, unless the worships wish to ask anything, these are my submissions. If there's nothing from the bench, then I'm finished. But you must first find out if there's no further questions.
Thank you.
The first issue, my justices, that I'll be addressing is whether the MEC can reject the application for subsidizing the sanitary pad initiative. My honorable justices, this is a very, very sensitive matter for the applicants, and as such, we do believe that it is one that should be addressed meticulously by this honorable court. I'd like to start off by mentioning Section 27 of the Constitution, which states that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. Therefore, my justices, we contend that the MEC, as a state representative, need not only to respect the right to education by female learners of Providence High, but also needs to fulfill this right as well. And part of fulfilling this right, my justices, is to accept the application for subsidizing the sanitary pad initiative. My justices, I'd further like to direct this court to what is perhaps the most important provision of the South African Schools Act, Section 34, which mandates that the state must fund public schools from public revenue on an equitable basis in order to ensure the proper exercise of the rights of learners to education and the redress of past inequalities in education provision. We humbly make it our submission that ensuring this proper exercise of the right to education includes providing sanitary pads for female learners at Providence High, just as how there has been provision made for transportation of learners to and from school, and just as how there's been provision made as well for a feeding scheme in the school. We say that these are all factors that contribute to the proper exercise of the right to education, and as such, the sanitary pad initiative should not be alienated on this ground. If it pleases the court, due to lack of time, I've only been allocated 3 minutes. I will now address my second issue in this matter, and that is whether or not the subsidy.
Sorry to interrupt you before you proceed. I just need to check something here. You referred to Section 34 of the Schools Act, which speaks about funding, correct?
Yeah.
I just need to take you back to Section 12 of that very same Act, which says the responsibility or the obligation of the MEC for education is the provision of education itself. Will I be correct? I just need you to help me. Thinking that issue of sanitary pads is about hygiene.
Sorry, can I get your question answered?
Sanitary pads is about hygiene, correct?
Yes, my lady.
Now, how does an issue of hygiene becomes the responsibility of the MEC for education? Why does it not go to SASA? You've also mentioned in your argument that you've touched on the issue of the provision of transport. And you know that the department that provides transport for the learners is the Department of Transport, not of Education. So why must the MEC for Education be burdened with issues of hygiene when those issues can be taken to Department of Social Development?
Thank you, my lady, for the question. As the applicant, we do submit that taking into account the nature of this matter, we are dealing with the right to education, and the MEC is obliged to take measures that will ensure that kids have effective quality to the right to education. I'd also just like to point out Section 27(1)(a) of the Constitution, which also states that everyone has the right to healthcare services, including reproductive healthcare. And because this issue is one that has a direct implication on the right to education, we therefore say that it is indeed one that falls under the duty of the MEC to ensure that these female learners are going to have access to education, because really without this provision for female learners, they will be excluded and prejudiced in their access to education, and ultimately getting good grades and scholarships that would afford them to go overseas to universities.
Just the last issue on that same topic, because I can see you can really think on your feet. When you bring Section 27 in, it means you're getting closer to agreeing with me that this is indeed a hygiene issue. And I think at the opening address you mentioned the Constitution, where it says the state, right?
Yeah.
So social development would still be the state that provides those sanitary pads through Department of Social Development. What do you say about that?
We'd like to believe that social development would also be, social development would also, fall under the fact that they would also, where mandated, they would have to also, offer a helping hand. But because the MEC is responsible for the schools in this area, as the applicants, we really do submit that the MEC must take all reasonable measures to ensure that the rights of learners are realized. We are not in any way suggesting that social development would also not, have a responsibility to ensure this right.
Thank you. You may proceed.
If that pleases
Yes.
my lady. I'd like to state Section 2 of the Constitution, which also provides that the Constitution is the supreme law of the Republic, and that law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. We submit to this Honourable Court that the conduct to exclude the sanitary pad initiative from the policy is unconstitutional, as it limits the right to education of female learners. Not only this, my ladies, but it also limits the rights of learners to equality and dignity. Moreover, as I've already mentioned, Section 27, I would like to also just elaborate that effective sanitary dignity is also vital to the health, education, well-being and empowerment of poor persons in such a school. In Section 28, subsection 2, which is also a very important provision, my justices, guarantees that the best interest of the child are of paramount importance in every matter concerning the child. Therefore, we submit that it cannot be in the spirit of the subsidy allocation policy that girl learners habitually miss school because they do not have access to sanitary products. We therefore submit that the policy is unconstitutional insofar as it excludes the subsidy paid initiative. If that would please the court, are there any questions from my justices?
Do you think poverty plays any role in this issue? Socio-economic conditions.
Yes, my lady, I'd like to believe that poverty does play a role because the female learners at Providence High cannot afford sanitary products, and as such, we would like to contend that we place such a responsibility on the state on such a right in Section 29 to say they should assist in this case because the female learners at the school are not capable of buying their sanitary products themselves.
Okay,
If that would please the
Thank
court,
you.
I would now like to hand over to my co-counsel.
May it please the court. My name is Talent Maluka, and I'm going to be dealing with the question. That is referred to in paragraph 6, which is the MEC entitled to reject the call for subsidy in respect of the sanitary pad initiative due to budgetary constraints? Section 29, Chapter 1 of the Constitution clearly states that everyone has the right to further education, which the state, through reasonable measures, must make available and accessible. In respect of the sanitary pad initiative, the MEC is not entitled to reject the call for funding thereof, as that would amount to discrimination and would unreasonably and justifiably limit the right to education for girl learners as provided for in Section 29 of the Constitution. The MEC would therefore be required to take all reasonable steps to ensure against the discrimination of girl learners from attending school due to lack of access to affordable sanitary products and making the budgetary adjustments required to realize this right immediately. Providence High receives about 90% of its budget from state subsidies. Failure of the MEC and his department in providing the access to sanitary products is tantamount to breaching his mandate in terms of Section 29 as set out in paragraph 6.2 above. What is the appropriate relief in this matter? I would like to submit to this court that earlier this year in October, the Minister of Finance announced during the medium-term budgetary policy statement that consumers will no longer pay value-added tax on sanitary pads. This can be seen as one of the ways in which the government has tried to remedy the lack of access to affordable sanitary pad products for all girls and women. It is therefore submitted by the applicant that the MEC for Education in the Northwest is obligated to adopt the sanitary pad initiative into the subsidy allocation policy because it falls within the subsidy allocation policy as explained in paragraphs 3 and 5 above. Failing to do so would amount to a violation of the girls' right to education as entrenched in Section 29, Chapter 1, Subsection B of the Constitution, infringing on the right to dignity and equality. The applicant requests that the decision to reject the policy by the MEC be declared invalid and the initiative be included in the policy. The applicant further requests that the respondents to the application attend to the allocation of a budget towards the sanitary pad initiative and as mandated by Section 29 of the Constitution. The applicants further request that legal costs to this application be borne by the respondents. If there are no further questions.
I do have a question for you. Actually, you have read the respondent's head of argument, right? Okay, so in the head of arguments, they raise an issue there. They say the provision of any service is also dependent on whether or not government can afford it, whether or not there are sufficient resources. And they mention the case for you there. They say in the matter of Grootboom, the Constitutional Court itself said consider whether or not there are enough resources. What do you say to that argument?
Okay, in terms of that argument, I would like to put it to this court that in terms of the right to education, it is a right. If I can refer the court to the amicus curiae supplement as a
Yes.
they spoke about the nature of the right to basic education
Where are you reading from?
in paragraph 1 of the amicus curiae.
This is the supplementary.
Oh,
Supplementary.
is it the supplementary?
Yeah.
Yes.
Yes, it is. Okay. Are we all there?
Yes.
Okay, so the nature of the right to basic education, it states that a right in the Bill of Rights can be expressed plainly as a right. For example, it can be unqualified, meaning that everyone has a right to basic education, and then with a qualification, for example, everyone has a right to further education which the state through reasonable measures must make progressively available and accessible, implied through expression of a negative duty. Okay, I'm actually looking for the one where it states that, where it speaks about where a right is realizable, then it means that the state must immediately realize the right.
Maybe it's the
1.4.
main-
Yes, that is 1.4, thank you.
Supplementary.
Is it there? So if I may read.
Yes.
Basic education, unlike some of the other socio-economic rights, this is immediately realizable. There is no internal limitation requiring that the right be progressively realized. Oh, okay, if you can go back to 6.3 of our heads, sorry. The MEC would therefore be required to take all reasonable steps to ensure against the discrimination of girl learners from attending school due to lack of access to affordable sanitary pads. I just want to highlight where we say that they have the MEC is required to take all reasonable steps to make sure that to ensure that there's no discrimination against the girl child.
Okay.
Does that answer the question?
About the issue of costs, why do you want costs on a constitutional issue? You say the respondent must pay the costs.
Oh, because we.
When you check something, you just say, can my lady or my lord give me a minute?
Please have a minute to.
But there's no lot here.
Confer with my colleagues here.
I'm still conferring with my colleagues.
Okay. So, coming back to your question.
I'm indebted to your ladies.
Yes.
Okay.
Oh, you don't say coming back to that question.
If I may. Okay.
If it pleases the court.
If it pleases the court. The reason why we request that the respondents further the legal cost to this application is because, just like we have submitted to this court, that it is the duty of the MEC to make sure that this right is something that is accessible to everyone. And again, taking into account that the school does not have enough funds to be, that it basically doesn't have enough funds. So it is therefore, it is not really our, what's the word? Our obligation to help with this matter, basically to enforce.
So
the-
in actual fact, you are saying that had they not opposed this application, we wouldn't be here. So now that because they are opposed, they dragged you into court, and you think this is a legitimate application, then they must pay for costs. Is that what you're
Yes, they
saying?
must, because we believe that this is something that also fits in within the policy allocation, because if these kids cannot be able to access education because they do not have pads, then it becomes the Minister of Education's problem, because it's their education that is being affected.
Thank you.
Just one more question, just to follow up on what my learned sister has asked you. You said something like the MEC must take reasonable steps.
Yes.
What if the MEC says, okay, if you are talking about poverty, and if you are at a certain socioeconomic class, you get a grant. The MEC says, but you giving those family grants, why don't they buy pets from the grants that they are being given by government? What is your submission on that?
If it kisses the court, can I discuss it? No.
You can actually even ask any one of them to assist you with answering.
Yes.
Yeah.
Your Worship, as my learned colleague, and I think it was advanced to my colleague here with regards to the hygiene and whether it falls within or not. Your Worship, it's not our submission that these are exclusive. It's not to say that we are not aware that there are other departments who are responsible as well in their capacities respectively to ensure that sanitary dignity for one is realized. We are saying that on the basis of this matter, which directly implicates education, this is something that falls within the policy because it serves an educational purpose. Without it, you are prejudicing a group of learners, particularly female learners, from access to basic education. And so our submission is not that we exclude the responsibilities of other states of other organs of state, apologies, but rather that it is also the mandate of the MEC in this respect because of their mandate with regards to the subsidy allocation policy and it serving an educational purpose. I don't know if my learned colleagues would like to add on to that.
Can I just take it further?
Yes.
This application is on behalf of only the school Providence, right? Would you have a difficulty if the MEC for Education were to say to you, can I speak to my colleague at Health to provide the girls here with sanitary pads? Would that alleviate the problem?
Your Worship, I don't foresee an issue with that. I mean, as long as it's not prejudicing, again, I think the end goal here is that it should not prejudice the girl learners in the situation. Whether that means on the part of the MEC, and we are not here to expand on the powers of the MEC or his office or his colleagues' offices. We're here to expand particularly on his mandate with respect to the school, particularly given the history around it, the allocations, the subsidies that the schools receive. He has a mandate here. How he resolves the matter on another level is up to him. But we're just saying if he's going to justify or base his exclusion of the initiative on the fact that there isn't a budget, for example, that is not the issue, or that is not the concern of the school in question. That within his mandate, according to Section 29, is something that must be immediately realized by the Department of Education. It doesn't fall within the school to determine on their behalf how they're going to resolve the matter.
Just one last aspect, but isn't the Constitution barring the State Departments from acting outside, exceeding their allocated budgets? I hear you say
Yes.
the MEC can't come to you and say, I don't have the budget for this.
Yes.
But, and on the other hand, the difficulty that the MEC, and I'm not speaking for the MEC, the MEC can say, but the same Constitution prevents me from acting outside of my budget.
Yes. Your Worship, I'd like to bring us back to our submissions, particularly around when we unpacked Section 29 in the first instance under my submissions, as well as when we referred to the Schools Act.
Yes.
Again, if we come back to the essence and the wording of the right, my colleague spoke about qualified and unqualified rights. Section 29 is a qualified right. It is immediately realizable. Obviously, we understand the socio-economic circumstances that the country faces, including the state itself, but the Constitution mandates that the Department of Basic Education ensures that it immediately realizes the right, unfortunately. So again, coming back to my previous points, it is not for us, or at least for the applicants in this matter, to pronounce on how the MEC goes about that. Unfortunately, that's not the burden of the applicants in this respect, but rather to run home that this is a right we are enforcing. In fact, the application has come about because we feel the Minister, the MEC, has failed to observe their role and responsibilities. And it's part of the reason why we're asking for the costs to be borne by the respondents, because again, we're enforcing something that should have been done already. If it pleases the court or the worships.
Thank you. Sibu, you wanted to add?
Just
Congratulating your leader.
I just have one comment to you. When you address the court, the High Court, you don't say your worship. Your worship is for the Magistrates' Court. You say, my lord, my lady.
Okay, thank you.
And when you're addressing constitutional court justice, you say justices, like Sibu was saying.
Sure.
Right. Thank you.
Yeah, so you finish with your submissions. Okay. And the respondents, are you ready?
if it pleases the court, honorable justices, my name is Tifiso Mona, and I'm the senior counsel for the respondents. And on my left is Prudence Mate and Mhlanhla Mondlane. And we'll go straight to our argument. The first question I'll be dealing with is to answer as to whether the sanitary pad initiative.
I don't think the court will allow you to go straight to your argument, because if I remember, there's application for condonation.
Yes.
You must first deal with that,
My co-counsellors
because
deal.
you have not been granted. You can't argue if you have not been granted condonation.
Okay, we filed an application for condonation, and our legal friends did not oppose the condonation.
They did not oppose. Oh, okay. So then you can continue.
Okay, if it pleases the court. My lady, the first question I'll be dealing with is to determine as to whether the sanitary pad initiative form part of the right to basic education. If I may refer the court to an article drafted by Shieto Simbo. In his article, he stated that the lack of a concrete and a precise definition of the term basic education means that no one knows exactly what the term means in South Africa, and compliance with Section 29(1)(a) by the state or by the government is therefore difficult.
Mr. Mona,
Yes, ma'am.
I'm sorry to interrupt you. In court, in real courts, when you are either not dressed properly or your posture is not correct, the judge would say, I don't see you, meaning your hands must not be in your pocket.
Yes, ma'am.
Proceed.
If it pleases the court. My lady, as I proceed, in dealing with this issue, the court has to distinguish between the right to basic education and the obligation of the state to provide access to education. In Section 29(1)(a), the Constitution guarantees the right to basic education in a slightly different manner from other socio-economic rights, in that it is an unqualified right. That means the state has an immediate obligation to achieve the right. Then, it is stated in paragraph 2 of our fact that the Providence Hope High receive about 90% of its budget from the state. Therefore, that makes it evident that the state has successfully achieved this right. Inter alia, the right to have access to education is primarily concerned about eliminating all factors which limit access.
What is it, your main heads? I'm not following.
Where are you reading from?
Where are you reading from?
I have drafted another document which I'll use for my
Or
own
for your prep notes? You're reading
Oh,
from
for your own.
Oh.
Oh, okay, sorry. Because I thought you are reading from your heads.
I may submit it to the court as an annexure.
Beg leave to submit it. But then you must also give your opponent. How many copies do you have?
I have 3 copies.
Yeah. You can't find it here. Okay, maybe you can just give the applicants a copy. It's fine.
Thank you.
So are you supplementing
Your heads.
your heads?
No, I'm not supplementing.
Just a
It's a logical
preparation.
flow for my oral presentation.
Then in that case, it was not even necessary to give them because it's not their heads.
Yeah,
we
it's
can
not
take
their
them
heads.
back.
You can just
Yeah.
refer us to the paragraphs that we
Yeah.
Yes.
Okay, sorry. This is something just you did just to prepare for your argument.
Yes.
Okay, no, that's fine.
And please don't forget, I know you're reading from there, but please don't forget to say, okay, I'm dealing with 5.1.1, and then when you move on to the next point, refer us to your the corresponding point in the heads of argument.
Yes.
Thank you.
If it pleases the court, as I was saying that in dealing with the duty of the state to provide access to education, and the duty of providing access to education is mostly concerned about eliminating all factors which limit access to education, and the factors must precisely fall within the scope of the right to education. Then paragraph 5.3 of the heads of argument from the applicants approved that the sanitary pad initiative precisely fall under the right to health care, which is enshrined in section 27 of the Constitution.
Sorry, may I just interrupt you? When you say 5.3, do you mean 5.1.3
Of the
of your
applicants.
heads?
Of the applicants'
applicants.
heads.
Set of the
Applicants.
Oh, the applicant's heads.
They approved that the sanitary pad initiative falls under the right to health care, which is in section 27 of the Constitution. And section 27 of the Constitution reads as follows. It states that everyone has a right to have access to health care services, including reproductive health care. And the sanitary pad initiative falls under the reproductive health care. So I submit that the applicant is legitimately anticipated to approach the Department of Health, which is more suited to fund the sanitary pad initiative. Otherwise, any conduct, the Department of Education will be performing the duties of the Department of Health. And if I may refer the court to paragraph 5.3.1 of our heads of argument, where the Constitutional Court dealt with, in the Kosa case, the Constitutional Court dealt with the exclusion of permanent residents from social assistance legislation. The court emphasized the significance of the values of human dignity and equality in evaluating reasonableness of the exclusion which was in issue. Then this precedent persuades my argument to show that there are no constitutional or any legislative obligation on the Department of Education to provide sanitary pads to female learners. Therefore, any damage to the dignity of the learners premised from the lack of sanitary pads towels cannot be accounted for by the Department of Education, but by the Department of Health or the Department of Social Development. Intent of this case.
In that case, what about Section 3 of the Act of South African Schools Act, which says that the MEC is responsible for compulsory learner attendance? How will the MEC make sure that there's compulsory learner attendance? If the learner says, I can't come to school because I don't have sanitary pads, how will the MEC play a role there?
the MEC can ensure that since most of the learners in the South African schools, they are earning the child care grant, the MEC can ensure that the grant is precisely used to cover the basic needs of the learners, which will include the sanitary pads for the learners, other than buying other unreasonable stuff which are not specifically for the basic needs of the learners. The MEC can ensure that the parents, they call meetings to educate, to give financial literacy to parents to buy the learners the basic, what they basically need to go to school, to attend school and to receive education.
But, but parents will say, I receive 1,000 something, and that 1,000 is only for food. And what are we supposed to do now? We must starve because we must buy the pets.
The money is for the children, and the school have feeding schemes. They cannot argue that, they cannot raise the point that there is no food at home. The children, they come to school and receive food. Then they can use the money which they're supposed to buy them food with to buy them the sanitary pads. Then they come to school, they get food, they have sanitary pads from their social grant, which is from the social development department.
Mr. Mona, yes, I wanted to say, and it is well documented and it's a well-known fact that these recipients of grants, they buy lipstick and weaves, ne?
Yes, ma'am.
Unreasonable expenses.
Unreasonable expenses, yeah. You may proceed, sir.
Thank you, my lady. If it pleases the court, I may proceed to deal with the second issue, which is to determine whether the initiative said can fall within the subsidy allocation policy or does it fall outside the policy. In dealing with this issue, the court must firstly draw its attention to the constitutional principle of legality and the proper exercise of administrative powers. The subsidy allocation policy, they form boundaries beyond which the school or the governing body cannot legitimately travel. If they determine to fund for an initiative which falls outside the scope of the policy, they will be conflicting with the constitutional principle of legality, because the policy was drafted by virtue of a legislative, with legislative power, which was enshrined on the concerned committee. Secondly, the court have to consider the reasonable practicability of the sanitary pad initiative. If the court condones the implementation of the initiative, this will cause a heavy financial burden on the state. The state is already providing social care grants to the children, and now if they have to provide sanitary pads to the children, not only, and this will not be only the Provident Hope High School, it will have implications to the national budget, because every school will have to be provided with the sanitary pads. We will have to have the sanitary pad initiative, mostly even the primary school, because some of the female learners, they start their menstrual cycle at an early age, and that will have a very huge implication on the national budget.
What about the fact that, I don't know if it's a Concord case, I've read somewhere where it says that educational purposes are more important than budgetary purposes, which means the government should not so much worry about the budget, but about the fact that a learner gets education.
In this case, I've stated that, thank you, my lady. In this case, I've stated that we have to differentiate between the right to basic education and the obligation upon the state to make education accessible. The state in this case has already provided 90% of the budget of the school, which have successfully achieved the right to basic education. Now we are dealing to making education accessible to the female learners, and in doing that, the state has to do that within its available resources. This one is it's a qualified obligation. It is qualified by the availability of resources. The state cannot be expected to do more than it could achieve within its resources.
Do you think that if you read the preamble of the Act, it says that the purpose of the Act of SASA, South African Schools Act, is to correct the wrongs of the past? Do you think that if the MEC says, I'm giving you grant, and I've done all I can to help, and the family says the grant is not enough, and still a girl child cannot go to school. Do you think that is correcting the wrongs of the past?
Thank you, my lady.
Because the girl child is not going to school because of her socio-economic condition. Is that correcting the wrongs of the past and eradicating poverty? Because one of the purposes of the act is to eradicate poverty.
Thank you, my lady. In answering your question, I'll say that then it wouldn't be appropriate for the applicant to sue the Department of Education, because if we're dealing with poverty is not predominantly an educational issue. It has to do with the social development, the well-being of the child learner at home, not in school. If we're dealing with poverty, we can say that the government has taken reasonable measures to eradicate poverty within the educational premises, because we have feeding scheme. If we raise the issue of poverty within educational premises, then I think we have a very reasonable solution, which is our feeding scheme. And then now, if we take it to their place of ordinary residence, then that will be only the Department of Social Development can have a say, not the Department of Education. Thank you.
Just one question or one comment, building on my learned sister's question. Eradicating poverty, correcting the wrongs of the past. So the right to education is the right to education is a fundamental right, and poverty is preventing these girl children from access to education. What do you say about that? Because poverty is associated with the past, and the fact that not many girl children in rural areas had access to basic education. So, could you elaborate more on that, please?
Okay. May I please the court indulgence and consult with my co-counsel?
Okay.
Mr. Mona, if one of your colleagues wants to answer that question for you, they are welcome to assist.
Okay.
And then you can go back to your submissions when they're done.
As the court pleases, Honorable Justices, my name is Agnes. I am the co-counsel. As the co-counsel, I am the respondent. I represent the NEC for Education this matter. Honorable Justices, in light of the questions that you've asked to my colleague, what I can submit that is, number one, Honorable Justices, as much as the state is obligated to fund the school, it must also be noted that the SGB, the parents are also obligated, they also have a positive obligation as well to help with the funds for the school in order for the betterment of the learners. So the obligation is not entirely on the positive obligation is not entirely on the MEC to provide the
Sanitary.
the sanitary pads. But the obligation also, the positive obligation also occurs within the SGB and the school as well. So in this instance, Honorable Justices, I will say it will have to be a consultation between the MEC as well as the SGB, because I've noted that in the Schools Act, it is also stated that the SGB as well as the parents are also obligated to raise funds for the school.
So they will also have to partner in with the MEC and assist. And the SGB can do this in a variety of ways, as it is of common cause, as well as in our facts, Honorable Justices, that they've once consulted with private institutions, like the lottery, to provide buses for the schools. They can also do the same things with the sanitary pads initiative. They can go to other departments like your Always ATRA and ask for donation in that regard. The parents can also assist. If they are able to afford school fees, they can pay the school fees, which can also be used in this instances, Honorable Justices, to supplement where the MEC cannot go further.
How do I as a parent, I mean, I'm a black woman, I'm not educated, I live in the rural area, I'm not working, my husband is not working, our girl child goes to school. The only thing that we depend on is grant. How do I help and contribute?
Honorable Justices, thank you for your question. Honorable Justices, in light of the question that you've asked, what I can say is, yes, you are a black woman, yes, you are educated, and yes, you are unemployed. But remember why the social grant was there in the first place, Honorable Justices. And in light of the fact that the Constitution stipulates that the best interest of the child are of paramount importance in any matter, it is therefore, Honorable Justices, also as a mother, taking into cognizance the fact that the best interest of the child is of paramount importance. With that social grant, Honorable Justices, you can use a portion of it to make sure that the child is catered for. Regardless of the fact that you are educated, you are unemployed, I know that every parent in this country wants what's best for their child, and the Constitution also says that as well, Honorable Justices. So the mother can actually use that portion of the money in the social grant, and just put it there for a month, just for sanitary pads. As we have, it's also been in the news, Honorable Justices, that the Finance Minister has also asked that some of the pads will not be taxed, Honorable Justices. So this will also go to the heart of the parents who are who are unemployed in this instance. They can buy those reasonable ones that are not taxed to afford for their children.
Yeah, they can buy the ones without wings. They're cheaper.
Yes.
Oh my gosh.
If the court doesn't have any further questions, that therefore concludes my submissions.
Thank you. Mr. Mona?
Okay. If it pleases the court, as I proceed, may I refer the court to the case of Supramani, where the Constitutional Court held that the obligation imposed on the state to progressively realize the right to have access to housing, healthcare, food, water, and social security are dependent upon the resources available for such purposes, and that the corresponding rights themselves are limited by reason of the lack of resources. Then, subsequently, in the Grootboom case, the court stated that the content of the obligation in relation to the rate at which it is achieved, as well as the reasonableness of the measures employed to achieve the result, are governed by the availability of resources. In the JC case, the court held that the obligation does not require the state to do more than is achievable within its available resources or to realize the right immediately. Meaning that the state must be given sufficient time to realize the right in issue. It cannot be expected to realize the right immediately to fulfill the obligation to make education available, accessible to everyone. So, with this, I submit that the sanitary pad initiative does not fall part of the subsidy policy. If there are no further questions, I may allow my co-counsel to proceed.
Go ahead. Just a comment, building on from what my learned sister mentioned about the court not seeing you, where a justice or would look at you and say, I can't see you. It's got to do with your attire. When you're presenting in front of a court, you should not wear a sweater. Maybe a tie. It's preferable to wear a jacket, a dark jacket, a tie, and a shirt. Or if you can't get hold of a jacket, then maybe just a tie, but not a sweater.
Thank you, Mr.
No
Mona.
questions.
If it pleases the court. Honorable Justices, as I've already highlighted before this Honorable Court, my name is Agnes Ndlandla-Mandane, and I, along with my co-counsel, represent the MEC for Education in this matter. Today, Honorable Justices, I'll be addressing two issues that are before this Honorable Court. Honorable Justices, sorry. My arguments will be based on page 8 of our heads of argument. So, Honorable Justices, due to the word limit, I've stated the Constitution, the provisions of the Constitution, but I will elaborate further on it, on my arguments. I just not include it within the heads of argument. Honorable Justices, as I've already indicated, I'll be addressing one of the two issues before this Honorable Court. The first question is, can the MEC for Education reject the application for subsidizing the sanitary pads initiative if the sanitary pads initiative were to fall within the scope of the subsidy allocation policy? The second question that I'll be addressing in this on behalf of this Honorable Court is the subsidy allocation policy unconstitutional in as far as it excludes the sanitary pads initiative? Honorable Justices, in light of the first question, in light of the first question, it is worth noting, Honorable Justices, that as much as the budget has been brought in front of the MEC from the school is saying that they require funding of 100,000 rand. Honorable Justices, it is worth noting that in this instance, the state will therefore not only, due to the right of equality in terms of the Constitution, the state will not only be funding the school in this particular instance, and that the MEC will therefore have to fund the entire province. So that is worth noting before I go further into my arguments. Honorable Justices, I'll be addressing the provision in my heads of argument, which is 6.1.2, Section 1, subsection C of the Constitution. Honorable Justices, South Africa has incorporated the doctrine of the rule of law in Section 1, subsection C of the Constitution, which provides as follows. The Republic of South Africa is a democratic state founded The Republic of South Africa is a democratic state founded on the following values. Number 1, the supremacy of the Constitution, and number 2, the rule of law. Honorable Justices, in that instance, Honorable Justices, it is therefore worth noting that within the South African context, what the rule of law actually means, it means that the government, or in this particular case, the MEC, must have the power provided for, or the authority, or rather the authority for everything it does, provided for by the law. Irregardless of the substantive, irregardless of the procedural or the national provisions of this, irregardless of the, irrespective of the substantive qualities or the procedural qualities of that law. Honorable Justices, it is therefore our submissions that in these instances, the MEC cannot